Case has been dragging on since 2020, so today's appearance may still largely be very much about procedure, and we may hear if the Hawks have tracked down Magashule's former PA. Or legal expert Sinao Makangela is keeping an eye on developments for us. Sinao, thank you so much for your time. It's a pre-trial hearing, which really means that the legal teams get together, sometimes even in chambers, to discuss the time frames for answering and replying affidavits and a court term, if you like, time frame.
Yes. Good morning, Anuka, and good morning to the viewers at home. It's a pre-trial, and I think it helps in most cases so that we don't find this back and forth when the trial starts. Because if you may recall, one question that was asked by the judge president of the Free State was whether the authorization they want, that is the accused persons, they want from the state is available or not. And what is it that is difficult for them to supply the information to the defense? Now, in this case, it appeared as if the state is not really in order. It's not ready to kickstart the trial. Because in terms of the act, it says before you can charge a person, you must have an authorization from the NDPP or the deputy. Now, that authorization, it will indicate that the NDPP first afforded an accused person an opportunity to give reasons as to why the person could not be charged, why the person has failed to act in terms of the Act, Section 17, Section 23, and Section 34. Where there's a property, where there are interests, or where the person has failed. That person first must be given an opportunity to give reasons. All that information must be written down. Now they're accused because they know where they are, that process was never followed. Now they are asking for the authorization, and the state does not seem to be having that information in its possession.
So now, Magashule filed papers last year requesting the state to provide him with a list of witnesses. Is that regular? I mean, surely the NPA should be providing witnesses so that the defense will know what witnesses they can and cannot call.
Exactly. Hence I say it's as if the state is on the back foot in this case, because the accused person must know which case is required to meet in court by getting the information of those state witnesses. He will be getting the statements from the state witnesses so that he prepare his defense. Once the trial starts, there are no surprises. So the state should be just providing that information, simple as that. The trial should kickstart. And remember, this will also help the judge president of the Free State to allocate this matter to a judge, and will be able to make that, to estimate the time so that when he prepares his roster for the judges, he knows that he must not interfere with a particular judge so that that judge can run through with this trial to finality, so as to finish the process. But now the judge president himself can't even make up that because he does not even know how many witnesses is the state intending to call. There are still these outstanding issues they need to iron out because the state says, well, these charges in terms of this act are alternative charges. But if it's a charge, there must be an authorization still. So whether this charge is one of those charges that the accused person will be required to meet in court. So those are the issues they need to iron out so that once everything is ready, they just shoot straight to the trial. Then the trial court starts with its trial and it just moves swiftly without any delays.
So there is some merit, according to you, Sinao, on Magashule saying that he is ready to go ahead with the trial, but the state is dragging its heels, and that's justice delayed is justice denied, and really putting his suspension, etc., and his livelihood on hold. Well,
because they say so, and we have to take their word when they say they are ready. State, give us the information. The state is not saying, I have given you the information. I've given you the authorization. They say the Act, Section 27, requires you, before you put charges, you must have had the authorization. Remember, even if they can get it now, it would mean it's like an afterthought process. They started to charge him without the authorization. So those will be some of the gaps in the state's case in this particular charge. Well, I don't know in respect of other charges. So the state needs to swiftly put its house into order. If they want to charge Mr. Magashule, they must quickly charge him. They must do what is right. Give him the information. Every accused, by the way, before you go to trial, you get those statements from those state witnesses so that you know who says what about you. You prepare your defense accordingly. You go to court, no surprises.
Absolutely. I mean, you need to know if you can call your PA, for instance, has turned a hostile witness, or whether she's become a state witness, 174. I mean, you need that information in order to prepare your defense, to be fair to Magashule. One quick question. He says this is a politically motivated trial. How do you prove that in a court of law?
Well, Anika, that's so difficult. I don't even want to entertain that space. Once the case comes to court, the court will be dealing with the case in terms of the law, not in terms of the politics. If the charge is in terms of this act, then that's why now we're dealing with Section 27. Section 27 has got its own jurisdictional factors. Then they must go through and see if those jurisdictional factors have been satisfied. If not, they make an application to court that charge must be quashed away, and then see to the next charge. Well, how he addresses his supporters, well, he may say it's a politically motivated case. Well, I don't know that space. But in court, whether there are politics or there are no politics, the state will have to prove its case beyond any doubt. Once there's a doubt, that will fall in his favor. If there's no doubt, if the case has done its own case, then he will have to face the consequences.
All right. Thank you so much there to Sinau Makangela, our legal expert. And just a reminder that the corruption and fraud charges that he has not been formally charged with or pleaded to amounted to a fraud of 225 million rand for that asbestos tender, and it's 21 charges in total.